All right, hello and welcome to Win Without Law School. I'm Arizona lawyer Julie LeBenz. Today we are going to talk about how to handle direct examination during a trial when you're representing yourself. So normally, if you had a lawyer, the lawyer would call you to the stand and then ask you questions, but you don't have a lawyer. So how does this work? That's exactly what we're going to talk about today. So first, I just want to remind you of the overall trial procedure. So first there's opening statements, and then the party that filed the petition, if you're at a final trial, or the party that filed the, for example, motion for temporary order, if you're at a temporary orders hearing, the person that filed either that petition or that motion, they go first. So they're going to present their first witness. And when they present their first witness, that witness gets questioned on direct examination, then gets questioned by the opposing party on cross-examination, and then there can be some final redirect examination where the witness can clear up or give some more detail about anything that was asked about on cross. The party that filed the petition or motion, they can then call their next witness and any other witnesses they have thereafter following the same procedure. Once they're done calling their witnesses, then it turns to the opposing party and they get to present their first witness, question them on direct examination, and then there's cross-examination and then redirect, and then same process with any additional witnesses. Now, once the opposing party is done, the party that filed the petition or motion, they have a potential opportunity to present one or more witnesses on what's called rebuttal. Often there's not time for this, and it's optional. You don't have to call a rebuttal witness, but you could call a rebuttal witness, and it could be you. You could be the one to go back to the stand. And during rebuttal, you're really going to want to focus on rebutting anything that came up during the opposing party's case presentation. So that's what the purpose of rebuttal is. And then finally, there's closing arguments if you have time. So if you were the party that filed the motion, then you could be your first witness. You may be your only witness. You're not required to have more witnesses, but you could be your first witness. And in that case, you will need to prepare to testify in direct examination and then testify on redirect. And then you could testify again on rebuttal, which is optional. If you did not file the petition or the motion, you are the responding party, then you could be your first witness when you present your case. And again, you don't have to present more than one witness. And you would testify on direct examination, you'd be questioned by the other side on cross, and then you would have a chance to do redirect. All right, let's look at if you are the petitioning party. So it doesn't necessarily mean you're the petitioner. It could if you're in a divorce or underlying custody case, a custody establishment case. But if you're in modification or enforcement realm, then the petitioning party may or may not be the petitioner. But really we're looking at who filed the petition or motion that is now going to a hearing or a trial. So let's look at this. So if you were the one that filed the petition or the motion that's proceeding to the hearing or trial, then you're at the trial, okay? You do your opening statements. Now the judge is going to turn to you and ask you to call your first witness to the stand. If you want to be your first witness and you want to testify, this is when you would just tell the judge, Judge, I'd like to testify, or I call myself to the stand. Either way is fine, but you want to tell the judge you are your first witness. At that point, you'll be put under oath. The court clerk will swear you in. You swear to tell the truth, nothing but the truth, so help you God. And then you take the stand. Now, you can potentially testify from your seat, like where you are over here, instead of going into the witness box, if the judge tells you to. So it just kind of depends on the judge. Some want you to come take the witness stand. Some like for you to testify from where you're already sitting. Either way is fine. From there, you're going to start testifying. Because you don't have a lawyer to ask you questions, you just get to start talking. And I encourage you to bring with you to the stand 1 or 2 pieces of paper with bullet points of what you want to talk about. And we'll get into that more in a minute. But it can be difficult to just talk off the top of your head and remember all of the points that you want to make. So that's where taking a piece of paper with bullet points can be very helpful, so you can hit all the points you want to make. Once you are done telling your story on direct examination, then the opposing party or their attorney will ask you questions on cross. And then once they're done with those questions, you can potentially testify one more time where you would clarify or provide additional information on anything that came up during cross-examination. So on cross-examination, in particular, if you're getting questioned by a lawyer, they're going to try to get you to just answer yes or no. And so obviously, if you're just answering yes or no, there can be a lot more detail you want to give. And so that's where on the redirect, you can give that additional detail if just the yes or no response wasn't sufficient. We have a question, what about exhibits? Yes, while you're testifying, this is while you would this is when you would present any exhibits you're wanting to present during your testimony. Okay. What do you testify about if you're in a divorce or legal separation trial? Or let's say it's a trial on a motion for temporary orders in a divorce or legal separation case. Well, first you're going to identify what are the disputed issues. Okay, I've listed out what could be potential disputed issues, and let's break it down by each type. So first is the division of property and debts. What is in dispute? What is your position regarding the disputed issue? And what do you want the judge to do and why? So when you testify, you could say, look, judge, we do not agree about what should happen with the marital home. You've identified the disputed issue. Now you can say your position. Judge, I believe that the marital home should be sold and the proceeds split. Why? Because I believe that is the most fair outcome. My spouse is proposing to buy me out, but they want to do so at a reduced rate. The house is worth more. I would end up getting less. You know, whatever your reasons are, that's what you'll want to do with each disputed issue related to property and debts. Spousal maintenance. If you're the one requesting maintenance, you'll need to testify about how you qualify. And how you qualify is listed in 25-319A. Watch the case strategy creation videos on spousal maintenance to get a bunch more information on that statute. But you'd want to testify about why you qualify, of course, present any exhibits on that point. And then talk about what is the amount you're asking to be ordered and for how long are you asking that that monthly amount be paid for. And then, of course, explain why that's justified. Legal decision making, if that is disputed, explain to the court what you're asking for and why that's best for your children. Parenting time, explain what your year-long parenting plan proposal is and explain why you believe it's best for your children. Child support, what numbers did you use in your child support worksheet and why? What is the amount of child support you're asking the court to order and why? Who should pay for medical insurance for the minor children? How should uncovered medical expenses be divided between the parents? And how should the child tax exemptions be divided between the parents? You'll want to explain your positions on all of these issues if they're disputed in your case during the trial. Plus, if legal fees and costs are at issue in your case, then explain each party's financial resources and the reasonableness of the positions taken throughout the case. That's what the law is. So the legal fees and costs can get a little bit complicated, but basically financial resources, you're looking at what does my spouse have as far as access to money to pay for legal fees and what do I have? So you can compare that. And then have you been reasonable throughout the case as far as the positions you've taken? And just because you disagree on something, that doesn't mean that it's unreasonable. It's more if like you're not providing the disclosure you're supposed to provide, or you're taking a position that has absolutely no ground in the law. If you've got a custody establishment case, so you have children in common, you've never been married, and now you want to get custody papers in place to establish legal decision-making, parenting time, and child support. Again, identify what issues are disputed by the time you're getting to trial. If legal decision-making is disputed, what are you asking for? Why is it best for your children? If parenting time is disputed, what's your parenting request or parenting time request, and why is that best for the children? For child support,
what numbers did you use in your child support worksheet and why did you use those numbers? So for example, gross income. Why did you use the numbers you use for gross income for each parent? Where did those come from and why did you use those? What is the amount of child support you're asking the court to order and why? Who should pay for medical insurance for the minor children and how should uncovered medical expenses be divided? And how should the child tax exemptions be divided? And then if legal fees and costs are at issue in your case, you can make arguments about the financial resources of each party and the reasonableness of the positions taken. Okay, I'll address some of these questions at the end. Okay, so what if you're dealing with a modification case? So you've already been divorced or you already established custody, but you're wanting to make changes to that underlying order. So if you're looking to change spousal maintenance and that's going to trial, what are the substantial and continuing changes in circumstances that justify the modification? And what are you asking the court to do? What do you want the spousal maintenance change to and why? This substantial and continuing change in circumstances that justifies the modification, that question is going to apply if you're looking to modify spousal maintenance, legal decision-making, or parenting time. Child support as well, the court usually looks at that as around a 15% change in the numbers. But overall, you need to explain what's changed, why that justifies modifying your order, and what you want the modification to be and why that's best for your children. So yeah, when you look at what's best for your children, you can definitely focus on the standards listed in 25-403. Those are the best interests of the child standards. And that's, you know, these questions about why, that can be really powerful, is when you're explaining why this is best for your kids, is to tie that into the 25-403 standards. All right, what if you have an enforcement case? Well, if you're looking to enforce the division of property and debts from your divorce, you're going to want to show, while you're testifying, proof that your ex-spouse violated the terms of your decree regarding division of property and debts, and tell the judge what you want the judge to do about the violation and why your requested relief is justified. For spousal maintenance, you want to show proof of the non-payment and then explain what you want the judge to do about the violation and why your request is justified. For legal decision-making, show proof that your co-parent violated the legal decision-making orders and explain what you want the judge to do and why. For parenting time, you want to show proof that your co-parent violated the parenting time order and explain what you want the judge to do about the violation and why. Child support, show proof of non-payment, explain what you want to do, what you want the judge to do as a remedy. And then if legal fees and costs are at issue in your case, then you can get into financial resources and reasonableness as well. All right, now what if you are the responding party? So the petitioning party, they just did their initial case, okay? They've testified, you cross-examine them, they did their redirect, and they only had one witness, they're done. And so now the judge is going to turn to the responding party and ask the responding party to call their first witness to the stand. So if that's you didn't file the petition or the motion that's proceeding to the trial or hearing. So then that's when you'll tell the judge, I'm my first witness, I'd like to testify, or something similar. Since you don't have a lawyer, you're just going to testify. You'll get cross-examined by your opposing party or their attorney, and then you can do final redirect if there's anything you want to clarify or provide additional information about. So same type of stuff. When you testify as the responding party in a divorce or legal separation case, identify what issues are in dispute, explain your position and what you're asking the court to do and why, and do that for each disputed issue. Same thing with child custody, legal decision-making, parenting time, child support. Explain to the judge what you want to do and why. And since you're at this position where you're the responding party and the petitioning party has already made their case, you're able to compare and contrast. So for example, the other side's request for parenting time is not in the best interest of the children because
and give your reasons why, but mine is in the best interest of the children because, and explain. So as the responding party, you're in a position now where you can really compare and contrast the disputed issues and make arguments about why the court should rule in your favor. Modification, you're going to need to explain what the substantial and continuing changes in circumstances are and what you're asking the court to do. Now, let's say you don't want the modification, so the other side's requesting it and you are arguing against it. And so then in that case, you could be producing evidence to show why there aren't substantial and continuing changes in circumstances that justify the modification, and explaining why the modification should not be granted. For enforcement, so this is where you would be accused of violating the order. And so this is where you would want to show proof that you didn't violate the terms. I'll need to update this slide a little bit and explain how you didn't violate any of these terms or, you know, any of the allegations that are being made. If you really did the violation, then you may want to explain to the court what happened, why you did it, and maybe that your acts were justified if that's the case. But if you did violate the decree and there's really not much to argue about, you know, as far as proof of the violation, then the main argument may be over what the court should do about the violation. So if the violation is not clear cut and you want to contest that you even violated the decree or the order, you would present that evidence here. On the flip side, if you did violate it, then the big argument could be about what to do about the violation. Okay. All right, now, as the petitioning party, you get that final chance for rebuttal. Okay, so you've done your case in chief, your opposing party presented all of their witnesses, and now there's a chance for rebuttal. Now, keep in mind that the judge may or may not ask you if you have any rebuttal witnesses. So if you want to present yourself as a rebuttal witness, you'll likely need to tell the judge right then and there, hey, I've got one more witness, me, I want to testify on rebuttal. You're going to need to be cognizant of the amount of time you have for trial. You may or may not have time to present yourself as an additional rebuttal witness. But if you can, this is where you tell the judge, hey, I want to testify one more time on rebuttal. And you'd get up, and because you don't have an attorney, you're just going to testify. And your testimony is going to be about what was raised during the other side's case and looking to rebut what they brought up. So if you're the petitioning party, you presented your case, and let's say parenting time's at issue, and you present your proposed parenting plan. And then the other side presents their proposed plan, and they make all these allegations that you're abusive with the child, and that's why you should have less parenting time. On rebuttal now, you can rebut those abuse allegations. This is why you get a chance for rebuttal, to rebut anything that came up, because you went first, the other side had a chance to present their case and rebut what you brought up. But now, if you don't get a final chance to talk, then what they said, you know, is just out there without any final say by you. So that's what rebuttal is about. It's not required, it's optional, but if the opposing party brings up a lot of stuff that you didn't even address during your case in chief, this is your chance during rebuttal to give the judge your perspective on those contested issues. All right, so that brings us to the end of this presentation. The rebuttal testimony is going to be the same as far as direct examination, cross-examination, redirect. And then you can get to closing arguments if you have time. So if you want additional information about direct examination, head into the other video in the trial skills series for more on direct examination. Also take a look at the video on drafting your trial outline, because that will give you more information about how to craft your direct examination questions. All right, thank you so much for joining me today. I hope this was helpful, and I wish you all the best with your trial or contested hearing.